Hello. In this recording of our Justia webinar, Copyright, Fair Use, and AI, James Gatto explores the complexity of copyright issues related to artificial intelligence, with a particular focus on whether training AI on copyright material is an infringement or fair use. Remember, if you'd like to see more Justia videos on law practice and legal marketing, be sure to subscribe to our channel.
Hey, Kenita. Welcome, everybody. I am glad you're joining in today. We have a very interesting topic, and I hope you find this very informative, and I do look forward to answering your questions, as Nina mentioned. Okay, so just briefly, I'm not going to go into my background. Nina did a good job. Here's just an overview, but I just want to stress I've been doing AI work for over 20 years. It certainly evolved, certainly with generative AI in the last couple of years. It's certainly taken a rapid leg up. As much as I've been doing work for 20 years, there's new stuff every day. So I'm going to try to get you current on what's happening here recently and look a little bit maybe to the future. So brief overview of what we're going to cover. We'll do a brief introduction, and we're really going to talk about some of the existing AI litigation. We're not going to really go case by case. I'm going to pull out some of the key themes and issues that are woven through these cases. We'll really take a look at, based on these cases, whether the training of AI and copyrighted material is an infringement or fair use, and a few related issues on that topic. Then we'll look at, there's a couple cases that are pending that involve the Digital Millennium Copyright Act, or the DMCA, which relate not so much to infringement, but as to whether or not, if you train on copyrighted material, whether there's certain obligations with respect to maintaining copyright management information, like copyright notices, et cetera. And then we'll wrap up with a look at kind of what the Copyright Office has done in connection with AI, and then we'll get to your questions. So just briefly, as far as introduction, I probably don't need to say this, but just to kind of set the context, I'm sure you're all aware that the legal landscape with AI is evolving rapidly. There's many different legal issues. Many of the lawsuits that are pending involve copyright in one way or another. And so the intersection of copyright and AI, I think, presents some unique challenges and opportunities for companies as well. And that's going to be the primary focus of what we look at today, in addition to those few other topics I mentioned. There's dozens of lawsuits pending that have AI copyright issues. Most of them focus on a couple of different things, and we'll look at this from a couple of angles. But one is whether copying material to train AI itself is infringement, whether the training and what results, the resulting model, is infringement, and when the outputs may be infringement as well. And then for those of you who work in copyright, you know that while unauthorized copying is an infringement, there is an exception if the use is deemed a fair use, and we'll talk about what that is and how that may apply in the context of AI. It's a very important exception to copyright infringement law. And then we'll take a look at the issues with the output of AI when they infringe, as I mentioned, with the DMCA and some of the copyright issues. Okay, before we get into this, I want to kind of take a couple poll questions kind of scattered throughout. Hopefully this all will work. But if you could each please answer this question to the best of your ability. Is copying of creative content to train AI copyright infringement? And we're talking just in the US with everything we talk about today. It looks like the predominant answer is yes, it is infringement. 42% of the people who responded said that. 32% said, I don't know. 15% said, I need more information. And 11% said no. And then the second question is copying creative content to train fair use under US, is copying content train AI fair use under copyright law? 17% said yes. 27% said no. 48% I don't know, and 8% I need more information. Okay, well, for those who don't know, hopefully we'll get answers to this in the presentation in the next few slides here. But thank you for taking that. It's interesting. So when we look across the lawsuits, here are some of the sample issues. I alluded to some of these earlier. Well, one of the key issues in roughly 30 cases involving generative AI deals with the training of AI models and the infringing outputs, as I mentioned. So, if you're using copyrighted material to train, is the training itself infringement, and or does there have to be infringing output? Um, on the DMCA question, just go a little bit deeper. There's one case in particular that's pending against um, Microsoft and GitHub that they have a tool that's referred to as an open source code generator. And what this tool is, it's trained on open source code, so it knows how to do coding, it understands coding, and it's used by developers to assist them when they're drafting code. And so literally there'll be a panel next to like the development screen that they're using. And in real time, it can auto complete lines of code. It can provide suggestions for code, and the developers can request code. The key issue in those cases is not so much infringement, because generally with open source code, you're free to use it for any purpose. But the caveat is that there is um, generally each open source code base has a license that goes along with it, and usually there's conditions and or restrictions in those licenses, and so you need to comply with them. And one of the conditions that's prevalent in many open source licenses is that you need to maintain the copyright information. So if there's a copyright notice in the open source code, you can use the code, but you have to keep that notice. And the problem is that with many of these AI code generators, at least arguably, this is one of the allegations in the lawsuit, is that when they get trained, the copyright information gets stripped out, but the actual code may still be reproduced. And so one part of the DMCA prohibits the removal of the copyright management information. And there's also some other open source license compliance issues that we'll talk about. So that's kind of what that case is about. There's a few other cases that we're not going to go into deep detail on. One is there's been a number of lawsuits that have stemmed from authors trying to obtain copyright for AI generated work, and they've listed the AI tool as the author because the tool is what created the creative content in that work. And same thing with patents. There's been at least one individual who used an AI tool that he designed to help invent, and he claimed that the tool itself invented some patentable subject matter. He filed a patent application, listed the AI tool as an inventor. In both of those cases, the Copyright Office and the Patent Office, respectively, rejected those applications in really kind of more summary way, saying that only humans can be listed as authors or inventors, and that you can't list a non-human as an author or inventor. After a few rounds in the Patent and Copyright Office on those cases, those cases did get into district court, challenging the office's decisions, and those cases have been affirmed. So I think, at least for now, absent some change, the law on that is pretty clear. So we're not going to go into it in much detail, but there is some precedent out there. And then one of the other issues that I'm not going to go into today, but I just want to mention, because this is in some of the lawsuits, and it's also another important issue and can be at least another whole hour topic on its own, is the concept of deepfakes. So beyond just copying content, there are a number of cases where people will use copyrighted content, whether it's an image of somebody or something else, and portray it in a false light, whether it's to embarrass somebody with like revenge porn, or to mislead somebody as to making it look like a political candidate was doing something that he wasn't doing, etc. So I'm sure you're generally familiar with deepfakes. So there's a number of those cases pending, but we'll not go into those today. Okay. One of the things I want to also point out, just as a cautionary note, is that for the most part, the lawsuits that have been filed to date have been against the companies that are tool providers and that are building and making AI tools available. I have no doubt, based on history, that as soon as there's some finding that there's actually infringement, you're going to start seeing users getting sued, and those cases will come in waves. And so I only mention that because a number of companies that I've talked to, seem to have not much of an alarm because they see the focus on the AI tool providers. But I think it's important as a company, if you're using AI, that you have policies to help mitigate against risks of using AI. And there's a number of things that go into those policies. I won't go deeply into it, but you want to manage how your employees use AI. You want to pick your tools wisely. Some of these tools are safer to use than others. The terms of use differ significantly. And one of the important differences between these tools is that some provide an indemnity to users and some do not. In fact, with some of the tools, the users actually indemnify the tool provider. Strongly suggest against that if you're trying to mitigate risk. The last thing I'll say on that is even for the tools that provide an indemnity, it's important to understand that some of them have certain preconditions. And so you have to use certain configurations or settings on the tool in order for that indemnity to apply. And if you make an indemnity claim, you're going to have to establish it. They put the burden on you to show that you actually complied with those obligations, or they won't honor the indemnity. So again, that could be another whole topic, but just kind of a word to the wise there. Okay. So I want to break down the issues we've talked about in a little deeper level, and kind of then we'll get into some of the cases and the more detailed legal issue. So we've talked about, is copying content to train AI models infringement? So if we think about it, there's like 3 steps. There's, you get some content and you copy it, and so you obtain it. So one question is that alone infringement? Then you use that material you copied to train your models, and then you deploy the models as part of a tool to produce output. So there's, kind of 3 different points at which there may be infringement: the copying itself, the trained model, and or the output. And so one of the questions that's arisen in some of these cases is whether there has to be infringing output, or is the training enough? And I'll cover that in a second. And then the question is, on the output, does it have to be identical or can it be substantially identical? And also, as we'll see under copyright law, there's this concept of derivative works, and we'll look at, when might the output of an AI model be a derivative work? And then, of course, if there's infringement under any of these arguments, or at least presumptively infringement, is fair use a defense? And lastly, if there's infringement, who's liable? Is it the tool provider or is it the user? Okay. So the short answer is, the answer is going to depend on the facts of each case. Sorry, there's not going to be a silver bullet answer here. It's really important to really dig in on the facts, of any case in front of you that you're analyzing. You need to look at the content types, right? So is it copyright protectable information, or is it just data that might be facts that are not protectable, or they fall into other categories? So protectability is going to be one of the issues. The next thing is, where do you get the content from? Many of the big AI tools are just scraping the web, and some of what they're getting might be open source material or open data material. It may be licensed, it may not be licensed. There may be other permitted uses. To the extent that any of the content you're using to train AI is licensed, you need to make sure that the scope of the license is consistent with how you're using it, and whether there's any limitations or restrictions or other obligations you must comply with in connection with using that content. It also matters how it may matter how the training is performed. There's many different ways to train AI models. We'll look a little bit at a high level of some of what happens with training, but it's important to understand that the training process may vary. I'll give you a very high level example. Some people claim that at least some models, they don't really extract information. Oops, this is kind of advancing on its own. I apologize. Some models don't really just extract information from the data, but they really basically just copy it and or compress it. And so you're retaining a copy essentially. That's not how most models work, but that's how some people have argued some of them work. So that might be an important factor when looking at one model or another. And then, as we'll see, the purpose for which you're using the content is gonna be very important in some of the legal analysis. So I think the bottom line is there's not going to be in my view, any per se rule that training AI on copyrighted material is an infringement or is not infringement. I think each case will turn on its own facts, and we'll look at some cases that look at kind of both ends of the spectrum, so you can see where courts have found that activity like this is infringement and where they found that it's not. Just briefly, copyright infringement, there's statutory provisions that anyone who violates any exclusive rights of a copyright owner is an infringer under 17 USC 501. The main rights we're going to talk about here, there's several different categories of rights. The main rights is the right to reproduce or copy and the right to make derivative works. We're going to focus on those today. And then fair use is also a statutory exemption to infringement. And it says, notwithstanding the provisions of 106, which deal with infringement, the fair use of a copyrighted work for purposes such as criticism, comment, news reporting, teaching scholarship, or research is not an infringement. So there's a statutory provision which is set forth here, but then the courts have developed a test. So it's not just looking at is something in one of those enumerated categories, but rather the court looks at this 4-factor test, and it's a balancing test. It's not a bright line test. It's not like if 3 out of the 4 are favor fair use, then it's fair use, or vice versa. So these 4 factors are important, and while each factor is important, many of the court decisions have really focused on the first and fourth factor as being among the more important. So when you look at the purpose and character of the use, whether it's commercial or not, is it one of the listed categories, nonprofit, research, et cetera? There's a number of factors that go into this, and we'll look at some cases that address these issues in a second. But this is looking at what are you using the copyrighted work for? The next is the nature of the copyrighted work. And part of this can get into whether this is something that's highly creative or minimally creative. So that kind of the strength of copyright, for example, might be relevant in the second factor. In the third factor, you look at the amount and substantiality of the portion used in relation to the copyrighted work as a whole. So it's kind of a mouthful, but if you're looking at, a 1,000-page novel and you take one line out of it, and you quote the author, that's not likely a substantial portion. If the work is one image and you copy the entire image, then you've copied the entire portion of the work. So you look at the relative proportionality. And then the fourth factor, again, which many of the courts say is among the most important, is what is the effect of the use of the copy that you make upon the potential market or value of the copyrighted work. So if you're using the work and copying it for a purpose that would diminish the value of the copyright or potential royalties to the author of that copyrighted work, then this factor is going to weigh against you. Where if you're really not impacting the market, you're doing something different, then this factor may weigh in favor of finding fair use. Okay, so I'm not going to go into great detail here, but I just want to give you at least a little bit of an example of how one way in which AI is trained. And this is pretty common technique. So clearly, in most cases, when you're using copyrighted material to train, you need to make and obtain a copy of the work. So there's already going to be a copy right there. And then what do you do with it? So typically, depending on the data, you may process it to get it into consistent formats. There may be some like data pre-processing that happens. But then really kind of the first substantive step that happens is that in most cases, the training data is tokenized. And what that means in simple terms, as an example, instead of having text or images, the data is converted into some numerical parameters because computers are better adept at processing numbers than images, for example, or text. So you might break down words or phrases into tokens and then create a numerical representation for that token. So that's the first part. So there's a bit of a transformation that goes on there. But then really what's more substantial is and this is really what makes AI powerful, is this concept of what's referred to as embeddings. And the embeddings is the process by which the model learns information from the data set. So it's not just copying the data, but what it's doing is taking these mathematical representations and extracting information from it that captures relationships between the data, so between words or phrases, and they look for patterns in the data. And it's that level of processing and that knowledge that gets kind of embedded into the model that enables it to be adaptive and not just spit out what was put into it, but to really create new content in a way that makes sense because it understands what words typically appear with other, related words, in what order they might appear, looking at whether it's sentence structure or overall document structure. All these types of relationships can be learned. And so in many cases, the model itself may not include a copy of the content. And I think that's important. In some cases, it may. And if it does, then I think that's a bit riskier. But as we'll see, in some cases, it still depends on what are you using that copy for, if indeed there is a copy of the content that was used. Okay. So with that as kind of background, let's kind of get into some of the prior decisions. So one of the most important things I think to keep in mind is this distinction here, is the difference of what a derivative work is versus a work that is based on some copyrighted work. And so typically the courts have found that a derivative work includes some type of transformation of the form of the work. So if you have a novel and you translate it into another language, all of the expressive content is pretty much there, but the form is different because you went from English to Spanish or some other language. If you adapt a novel into a movie or a play, again, the expressive content is going to be similar, maybe not exact, but doesn't have to be. But you're taking the expressive content from a novel and putting it into a movie or play format. Or you may recast a novel as an ebook or an audiobook. All right. So again, it's a different form of the work, but one is a paper novel, one is an electronic version or an audio version. So that's what a derivative work is at a high level. It's a transformation of form, but typically the same or similar expressive content. When you copy for purposes, when you look at fair use, the question is the copying for purposes of criticism, commentary, or any of the things we looked at in the statutory definition of fair use. But beyond just those categories, really the courts have kind of broadened that out a little bit. And they look at a high level at whether the purpose for which you're copying is a transformative purpose, not just a transformative form. And one of the key cases that goes back to 1994 in this Campbell case. And so, one of the things that's important to understand when you're looking at copying is it just changing the form of something, or is it really copying, at least intermediate copying, but doing it ultimately to provide a different purpose that you're providing based on the work from which you copy it. We'll see some cases in a second that maybe clarify this a bit more. So one of the cases, Trust, the Second Circuit case, and in that case, the defendant copied books, copyrighted books, and as I understand it, they copied the entire book. And the purpose for which they did this was to identify, kind of create an index of what was in the book, right? Words that appeared and what pages they appeared on. And so the court in that case found that creating an index of a book, or a searchable index of books, was a fair use because it wasn't really reproducing the book. It was making the books, it was easier for people to find information in the books and other beneficial purposes. So that's one case where the court found a transformative purpose. In the iParadigms case, and then these next two cases go back a ways, they found fair use where the defendant copied an entire manuscript. There was one work at issue, but the purpose of it was to determine whether the original work included matter plagiarized from other work. So it copied it, scanned it, and did some analysis. So again, it wasn't to really reuse the work to output it and make it available to others. It was to do an analysis or extract information from that work itself. And even going back earlier in the Perfect Ken case, they sued Amazon. And in this case, the court also found fair use. And what Amazon was doing was providing a digital thumbnail copy of original content to provide a link back to the original. So they weren't producing like high res, big full size pictures. It was just a little thumbnail so people could click on them and go to the original content. So all those were found to be different purpose. Okay. More recently, one of the big lawsuits that happened a few years ago was Authors Guild versus Google. The Authors Guild represents a lot of authors, as you might surmise if you don't know that. And what happened was there was a program where Google, in conjunction with many libraries, undertook to scan and digitize printed copyrighted books. And like the Happy Trust case, they were creating a searchable database of these books with an index, so you could determine where information was and what information was in a book. But unlike the Happy Trust case, Google didn't just output an index, like saying, here's the words that appear and here's the pages. But if someone did a search, it would actually provide what's called the snippet view, which was, not only the words that were searched for, but, some context around it. It's similar to how they do other search results. And in this case, there was debate as to whether by reproducing some of the copyrighted content, whether that crossed the line into infringement or whether we're safe under the Happy Trust decision. And the Second Circuit granted summary judgment in favor of Google, again finding fair use. Second Circuit affirmed and Supreme Court denied cert. Part of the finding in the fair use analysis here was that they said Google was actually providing a public service by scanning computer-aided books. It was making it easier for people to find books of interest for different topics. And particularly if it was a book that was maybe rare or hard to find on an obscure topic. And they found because they weren't really reproducing the books, it was really more of an information tool about the content in the books. And so they found that was a transformative purpose. They also found there was no adverse impact on the market for books because they weren't reselling books or it didn't obviate the need people to buy books. In fact, the court said that this actually might help the market for books because it's easier for people to find books, as I mentioned, especially obscure ones. Okay. So then there was another case, the ebooks case, Hachette Book Group. So the Internet Archive, again, very similar to Google in the first half of the facts here. During COVID, they created a national emergency library where they scanned copyrighted books, printed books, to create ebooks as part of what they called a controlled lending program. So if you were a library, they would create a digital copy of a book for you, and the library could lend out at any one time either the physical version they had or the digital copy that related to that physical version, but not both at the same time. And so the argument was, we're not impacting the market for books. We're making books available for people who can't get to libraries. And in this case, of course, because they're making copies, there was presumptive infringement. The question was it fair use? And the court said it was no fair use. And in this case, despite the good intentions and despite the limitations on whether it's one book or a physical book or an ebook, the court found that this wasn't a transformative purpose. It was the ebooks were just an alternative form because it reproduced all the expressive content. And it also found that it did impact the commercial market because many book publishers sell both a physical version and an electronic version. Okay, so when you look at Google Books and ebooks, they're kind of at different end of the spectrum, even though there were some similar facts. Books were copied, right? And so you have to look at the totality of the facts and the purpose to really kind of reach a conclusion. Okay, so very recently, probably one of the most significant cases that have been decided in the AI copyright realm was the Thomson Reuters Ross case. And in this case, Ross copied. So I'm sure many of you are familiar with Thomson Reuters. They have a legal research platform. They have the rest of all the headnote system that they use to help index topics within legal research, within judicial opinions, and they make that available as a legal research tool. As part of Ross training an AI model, they I'll simplify the facts, but they basically copied many of the legal headnotes from the Thomson Reuters platform, and they used it to train AI. But they did not. None of their output included the headnotes. They used it to train the AI on legal topics from judicial opinions, which were not copyrighted. And so it was interesting. They thought that they had, and in this case, had some initial early decisions. I won't go through the whole history, but I encourage you to read it and see how the court evolved its jurisprudence in this case. But in this case, the court found that the headnotes were a compilation of protected material, and that each of the individual headnotes had individual copyrightable material as well. So, one of the questions was are the headnotes themselves even protectable? And the court in this case found yes. So then the question is, was the copying of those headnotes, even though they weren't output, was that fair use? And in this case, the court went through the four factors I mentioned earlier, and I'll walk you through them kind of quickly here. When you look at the use, purpose, and character, was it a transformation of form, or was it for a transformative purpose? The court found that the use was a commercial use, and it was not a transformative purpose. They found that Ross used the headnotes as AI data to create a competing tool. So they took the headnotes from a legal research platform to create a AI research platform. So this factor was found not to favor fair use. The nature of the work. The court noted the headnotes met the minimal required creativity for copyright protection, but that they weren't very creative. A lot of the headnotes, it was argued, were really just copies of segments of judicial opinions or words that appeared in opinions, and they weren't creative. But the court found that they were creative enough to be copyright protectable, but not very creative. And so they found that this factor weighed in favor of fair use because of the minimal creativity. The third factor was how much of the work was used. And this is an important point, not just for this case, but to keep in mind, because I think people sometimes confuse what this part of the test goes to. The court found that Ross's output, as I mentioned earlier, Ross's output when used does not include any of the headnotes. And so the court stressed that what matters is not the amount and substantiality of the work, portion of the work used in making a copy, but rather the amount and substantiality of what is made accessible to a public for which it may serve as a competing substitute. And so here, because Ross didn't output the headnotes, it found that this factor favored a finding of fair use. And then on the fourth factor, which is the impact of the work on the market or potential market for the copyright owner's market, the court found, after stating that this was the most important factor in fair use, it basically found that Ross purposely competed with Westlaw, which is one of the parts of Thomson Reuters, by developing a market substitute. Again, because this was copying from a legal research tool to create a legal research tool, they found there was direct competition. But there was a second argument, and that was that allegedly, if I understand the facts, Thomson Reuters hasn't licensed its headnotes to others, to which many companies now are licensing valuable data they have to third parties to train AI. So there is a market for that. But they found that Thomson Reuters hadn't yet exploited that market. But it found that notwithstanding the fact that Thomson Reuters hadn't actually done that yet, the court found that there was an effect on the potential market for Thomson Reuters to license its data for AI training, and that was enough. And so it found that for this factor, it weighed in favor of no fair use. So when you look at the scoreboard here, there's two factors that favored fair use and two factors that didn't. The court can't call a tie on the issue. And so it found that there was no fair use in this case because the first and fourth factor it indicated were more important, and those both dictated against fair use. Okay, so next poll question. Does this decision mean that fair use is not a viable defense when you're using copyrighted content to train AI? 55% said no, and that is the right answer. I think it's really important. We've seen a lot of articles about this case saying the court found that fair use doesn't apply to training AI. I think that's an over extrapolation of this case. First of all, I think this case will be appealed. I'm not judging whether it's going to win, or the appeal will win or lose, but I do think it'll be appealed. There are a number of aspects of the opinion that a number of people question the legal soundness of, but we'll see if that gets appealed. But I think most importantly, the facts here are different than in many of the other cases that are pending. In many cases, a book was used to train AI, and you're not copying that book. You're creating a tool to create new content. It could be a book or it could be something else. So at a minimum, there may not be direct competition, even though there may be impact on the market for that one piece of copyrighted work. So I think the bottom line is each of these cases will be fact specific. We'll see some trends with similar fact patterns, but I think you're going to see different results in different cases. Okay, so just to kind of move along here, we talked about the transformative form versus purpose. So one of the questions is really that where the focus should be, or really more how is the model used, and must there be infringing output? And I think what we can discern from the cases so far, people look at, is training AI from, let's say, a set of books to create more content. If it doesn't reproduce the book, is that, transformative? Is it more like Google Books, or is it more like the eBooks case? And is it similar to or different than Ross? And I think we'll see different cases answer this question differently depending on the facts. Okay, so this leads us into the next question on this is, if an AI tool is capable of generating infringing content. So let's say you have training on books and you create a tool and it can create all kinds of things, but it can reproduce substantial portions of the book. Does that itself make it an infringing tool? So is it capability enough, or do you have to prove that it actually did it is kind of the second part of the question. So let's try to get some answers in on this one, and then we'll talk about this a bit. 73% said there must be infringing output. I think that's going to prove to be the right answer. The reason I qualify that a little bit is what we've seen so far is that some of the decisions on preliminary motions, on motions to dismiss, have been granted in a number of cases where the plaintiff has alleged that their work was copied to train an AI model, and they allege that the tool was capable of copying all or some of the book. And the courts have basically said, you haven't shown that there's actual copying. And so they've typically granted the motions to dismiss, often with leave to amend, if the plaintiff was able to, establish infringement. In some of the cases, like the Getty Image case and the New York Times case, they provided as part of their complaint evidence of actual infringing output. So I think if you're filing lawsuits, you want to provide some evidence. Whether it ultimately turned out to be legally necessary or not, it seems to be what the courts are requiring for these cases to stick. Okay, then I think one of the last questions on this topic is generative AI output a derivative work of content on which it was trained? And just as context, some of these cases have filed saying, look, in order to train the work, you need my material. So anything that's generated from it is going to be a derivative work, at least to some extent. Does that sound like a true statement or not to you? So 61% say it is, 21% said no, and the rest either don't know or need more information. So on this one, I think the majority may be wrong, or I may be wrong, but I think that if you look at least at one of the decisions that was recently decided, The plaintiffs basically alleged that Meta's Llama model uh, themselves are infringing derivative works because they can't function without the expressive information extracted from the books. This is slightly different than whether the output is there, but this is even a more direct. Like they're saying that because the content is there, it's a derivative work. And in this case, the court basically said that the argument was nonsensical. And it basically was not a recasting of the work. As I mentioned, it looked at how the model was trained and it arguably extracted information from the work. So, I think, again, this is fact specific. The majority may be right here in some cases, depending on the facts. But I think this is another issue that we're going to see different results in different cases based on the facts. One thing I just want to point out too is that some people ask whether fair use is a defense to derivative works as well, or just infringement. And the answer is, at least for the NIMR, that it is. Okay. So then the question is, who's liable? Let's say there's infringing output. Who's liable? Is it the tool developer, the user, or both? And I think here there's arguments both ways, but there is some Supreme Court precedent, particularly the Sony case, that's held that a technology manufacturer can't be liable for a user's copyright infringement if the technology enables substantial non-infringing uses as well. So this was back in the days of the Betamax and the copying of videotapes, and the court held that Sony wasn't liable for selling the tape recorders because people could use it for legitimate purposes like time shifting and watching shows at home. Even though it could be used for unauthorized purposes as well. So I think we'll see this case often cited. There may be facts that differ from this, but at least at a high level, I think that this is what many of the tool providers are relying on as part of their defense. This is an important point too. So I think from a policy perspective, a lot of the copyright owners are saying, "Hey, look, the Copyright Office, the copyright system is set up under the Constitution to reward copyright owners for sharing their work so they can enjoy the exclusive rights." And that's partially right. But I think this is, and I'm not saying what the law should be. I'm just saying here's a case where the Supreme Court has said that the reward to the owner is a secondary consideration. And it said that the sole interest of the United States and the primary object of the Constitution conferring a monopoly lie in the general benefits derived from the public by the labors of authors. So if this rationale is adopted, when it comes down to whether, if you create a tool that can generate new books, right, assuming it doesn't copy, from an existing book, it might impact the authors. But, under this theory, some of the courts might say, hey, this is for a public benefit. It's kind of unfortunate to the individual owners. We'll see how this plays out, but I think this is an important case to keep in mind in that policy debate to the extent we get to the policy point on that. Okay, so moving on from the infringement to the DMCA. So I kind of talked a little bit about what AI code generators are, how they're trained on open source code, and in this particular case, the plaintiff alleged two things: that the GitHub, they breached the contract for failing to comply with open source license obligations, and it removed the copyright management information. The court dismissed the DMCA claim, saying that the plaintiff, again, this goes to the output, the plaintiffs failed to meet Section 1202B of the DMCA's. They said there's an identicality requirement. And what that means is that unless the output is identical to material you copied from, there's no obligation to maintain copyright notices. And on the other, I'll come back to that in a second. And then on the other claim, as far as the failure to comply with other open source license violations, the court didn't dismiss that claim. So some of the licenses have things like if you copy some or all of an open source program, you have to give attribution to the author, right? Different than copyright information, you have to say who the author is. And there may be other conditions as well. So there's a link there if you want more information. So this case is going on, at least with respect to the breach of contract claims. But what's interesting is, because there's a number of other circuits that have taken a different position and they don't require identicality in the output, there's a conflict among the circuits. So this case was actually certified for interlocutory appeal to the Ninth Circuit on the question of removal of copyright management information. So we'll see, how this proceeds on appeal. This is one of the cases from the Southern District of New York that found that it could proceed without requiring identicality. So if you wanted to see one of the conflicting cases. Okay, so the Copyright Office, some of these next few slides are pretty dense. I'm not going to cover them in great detail. They're really more for your convenience to take away, and there's links to a lot of useful information here. But at a high level, the Copyright Office launched an initiative back in 2023. They issued a notice of inquiry on a number of copyright issues. They wanted to get public input. They received over 10,000 comments on their notice of inquiry, and they're doing a report based on their review of the comments. And because of the how voluminous the comments were, they indicated they were going to publish the report in 3 parts. They published the first part in July of 2024, which addressed digital replicas, deepfakes, and use of name, image, and likeness, and other copyright-related issues on all that. So there's a link there to that report. Not going to cover that in detail. In January of 2025, they published part 2, which addressed the copyrightability of outputs created using generative AI. And basically, they reiterated a lot of what they said in their initial guidance back in March of 2023. One of the key takeaways is, as I mentioned earlier, you just cannot have a non-human author. And I'll come back to one part of that in a second. And then the third part of the report will be issued soon, and it's going to cover a lot of the issues we talked about, including the legal implications of training AI models on copyrighted works. When's it infringement? When's it not? What's fair use? Different licensing considerations for copyrighted content for training AI, and the allocation of liability. Okay, so again, just to go through this kind of quickly, human-authored original works are protectable. Includes compilations, derivative works. I'm going to go with what a compilation is in case people aren't aware, because some of the things we're going to look at in a second refer to compilations. So a compilation is a work that's formed based on collecting, assembling, arranging prior works, right? It could be original works or prior works, but it's some collection or arrangement of different works, whether they're individually protectable or not. So if you get a registration for a compilation, you basically get protection for the material selected and the way it's arranged. It doesn't give you protection for individual elements within the compilation, unless those are separately protectable elsewhere. Okay, so one of the other big issues in copyright that we've seen is when some of these cases have been challenged that the output of generative AI can't be protected because the AI itself generates the expressive content. A lot of people have argued, but the user provides the prompt. The user has the idea that tells the system what to create. And so, isn't the fact that the user comes up with that creative idea, like if you want to have a blue monkey holding a banana on the moon, that's an expressive idea. Why shouldn't that be protectable? And the short answer is ideas are not protectable. That is what the Copyright Office has said. And even in cases where a user has iterated prompts many times, the Copyright Office, in most cases, has refused to say that the output of AI was sufficiently human generated. So that basic piece seems to be at least pretty firm from the Copyright Office perspective right now, and at least one court has confirmed that. So the question is, okay, well, if AI can't be an author and it can't be the creator or of expressive work, what happens when a user, if there's really some expressive content created by a user and maybe AI helps modify it, right? So if you have what would otherwise be a joint author situation if AI could be a joint author. And the Copyright Office has published guidance on that. And again, what they've said is there's no prohibition on using AI to help create copyright protectable works. But the key thing is you can only get protection for the portion that was human generated, the portion was human creative content. And so typically what this means is when you file a copyright registration, if there's AI work in it, you have to disclose that to the Copyright Office, and you have to disclaim anything that was generated by AI. This gets into the more detailed elements of the guidance. Again, I'm not going to go through this point by point. A lot of this is pretty detailed, but again, it highlights some of what I just said in a little bit more detail. The Copyright Office does confirm, again, there's no prohibition on using AI to help, but you still have to look at what was created by humans versus the machine. Okay. Yeah, and the disclosure requirements and the right to disclaim I mentioned. And one of the things when they came out in 2023 with this guidance, they were saying it applied retroactively. So if you already had a registration that was AI, it was AI or partially AI generated, even if it was already registered, you had to go back and tell them and disclaim anything that was not. And if you didn't, and it was determined that you violated this requirement, you would lose the registration. Okay, so let's get into a couple of examples of actual cases where Copyright Office has looked at this material. So Stephen Thaler, creative guy, he's filed both copyright applications and patent applications naming AI as the author or inventor. This particular work that's shown here was called A Recent Entrance to Paradise, and he acknowledged that it was an AI-generated work that was created by a system that he developed called the Creativity Machine. So he built the machine to create expressive content. I'm sorry. He listed the Creativity Machine as the author. Case was rejected, not surprisingly, based on what I said earlier. Copy of the board decision is here. He filed a complaint in the district court, and he lost there too. Sorry, I'm missing a link there. I can send it if anyone needs it. Okay, so that case was pretty straightforward because it was a non-human author that was listed. A more interesting case, and one from which I think some interesting points can be discerned, was Chris Castanova created a comic book called Zarya the Dawn. And you can see in the top left there, Chris listed her last name and Midjourney, which is an AI tool, in her mind, disclosing that it was kind of jointly done by her and Midjourney, because that was the tool she used. The Copyright Office granted this registration. But then she published something on social media saying, hey, I just got a copyright on AI-generated comic book. And the Copyright Office said, we did what? So they basically sent her a letter and said, hey, we understand you used AI to generate this. We're going to reevaluate the registration we've already granted. They sent her a bunch of questions. She worked with a lawyer to respond. They provided detailed information about all the iterations of the prompts she did. I actually spoke with her about it. She spent probably hundreds of hours working on this. And the Copyright Office basically said, thanks for all the information. Here's what we're going to do. The images are not copyright protectable because they were AI generated, even though you had multiple iterations of the prompt. There was really no dispute that she actually authored the text and that she kind of did the layout of the text and even the AI images that were used in the comic book. So they gave her protection for the text and they gave her protection for the compilation of the material in the comic book, including the AI content and her own content. But again, it only covered the compilation. It didn't cover individually the AI content. So they canceled the registration with respect to the AI images. Copy of the decision is here. So you can see one of the things that is important to understand is when you're filing a copyright, as always, it's important to understand what category of work or what categories of work am I seeking protection for? And if AI was a part of it, how does that impact what parts of those might be protectable or not? In another case, this Theater d'Opera Spéciale, you can see the work here. The board found that the work contained more than a de minimis amount of content generated by AI, and said, we'll grant this because there was some original work, but you have to disclaim the AI generated content. And the author fought this and didn't want to disclaim it. And so because he was unwilling to disclaim the AI generated work, they wouldn't register it. This is another case where this work on the right, there was a registration filed for this image on the right that was filed by this gentleman named Mr. Sane, and he used this tool, RagHav, that he developed that was an AI painting app, according to him. So he listed himself and the tool as authors. And what he basically submitted was on the bottom left here, you see there was an image that he painted on the bottom left. I'm sorry, original photograph that he took. And then on the right, many of you may recognize this. This is a work by Van Gogh, Starry Night, and he basically asked the AI tool to take his work and modify it in the style of Starry Night. And so what resulted was the photograph on the right. And again, the Copyright Office, even though he chose a number of variables and values and the amount of there's parameters within his tool as far as settings essentially that he selected, the Copyright Office found that in this case, not only could you not have joint authors, but they couldn't really distinguish what was his work versus what was from the computer program. And so that in that case, the application was refused as well. And then in the last, I think the last one here, this work is called American. I'm sorry, a single piece of American cheese. You can see a little cheese on top of the lady's head here. What was interesting about this is that this artwork was entirely generated by AI, but you can see there's many different like pieces to the work. And apparently, the CEO of a company called Invoke, and Invoke has an AI editing platform. They individually modified a number of these pieces and like arranged them. And so, even though each element of this work was AI generated, he got a compilation after some battle with the copyright office. He got a compilation on the overall work and the pieces, how they fit together. So again, a slight variation on some of these other cases where there's at least some original content in the first Casanova case. Okay, and then this was one more example that I don't have the image for, but there's a work called "A Collection of Objects Which Do Not Exist," and they also got protection for a compilation. So I kind of rushed through that last slide there because we're at the very end right now. Thank you all for hanging in there. And happy to answer any questions, but let me turn it back over to Nina first. Any other comments?
Awesome. Thank you so much, James, for your insights and that wonderful presentation. So we can now move on to Q&A. Just a reminder, if you do have a question to submit, you can go ahead and do so by clicking the Q&A button in the control panel at the bottom of your screen and submit them there. James, it looks like we've already got a few. If you want to go ahead and kick that off.
Sure. Thank you, Nina. So the first one asked, as a threshold question, is training an AI model equivalent to copying? And again, I think we covered this, but for the most part, no, not necessarily. You typically have to copy material in order to train AI, but the model itself may or may not retain a copy. It's going to be fact specific. The next question says this may be off topic, but can someone sue due to falsified information generated by an AI tool? The answer is yes. There's in fact at least one lawsuit that was pending. I believe it's still pending, and there was some preliminary motions on that one as well. But there was I believe it was a radio host, and an AI tool generated content that said that he had defrauded a nonprofit, and he was being sued by the nonprofit. And neither of those was true, and so he sued for defamation. To my knowledge, that case has not been finally resolved, but he got in the front door of the court. So I guess if the facts are right, you can sue for defamation or potentially other damages if there's false information. And in that case, I believe he sued the AI tool company. I don't know if he sued whoever generated the content. Okay. Next one, it says, interestingly enough, an information database licensing case, Ticketmaster versus Tickets.com, held that downloading copyrighted data does not count as an infringement if the actual copyrighted data isn't used. I would guess that's probably why AI downloaded content isn't a derivative. Yeah, I think to a certain extent, I remember that case. That was really about scraping, and Tickets.com generated a they scraped from multiple ticket sites, create a master index of tickets that were available for people for repurchase. And I know a lot of the case there was about the terms of service and some of the other issues. So I think that was fact specific, but it may be that depending on why it was copied and whether or not the copyrighted material was actually outputted, factored into that. But I think that was kind of fact specific. Next question, if you use an AI tool to generate a YouTube title, is that a copyright violation? I would say not necessarily, to the extent that, based on the factors we talked about earlier, if it's an original title that the tool creates, it likely is not copyright infringement. However, you probably cannot copyright protect it either. So if someone were to copy it, you may not have a copyright claim against them. There may be other claims or other bases, but that's the one downside. And again, when I talked earlier about generating, use policies for employees, I stress this because this is one of the things I'm doing with a lot of companies is helping them develop policies that take into account a lot of different AI legal issues when they're permitting employees to use AI. And related to that point is that one of the things that companies will do in some of these policies is they will determine what AI can and cannot be used for. And so if a particular employee is employed to create expressive content, and you typically want to protect that with copyright, often that use will be prohibited in some companies' policies because you're not going to be able to get copyright protection. There may be exceptions to it. You can use AI for inspiration, but not copy the outputs. I mean, there's variation to the policies, but the key point I think is it should be addressed in the policy so you don't inadvertently use something that you don't know is not copyright protectable. What happens if you use personal material and vocabulary to train your own AI? Is that protectable? Again, other cases pending on this. So when you say personal materials, if you mean personally identifiable information or PII, that may be problematic. It may be a violation of privacy laws, depending on what the material is, how you obtained it, etc. And vocabulary, there are a number of cases that are pending. If by vocabulary, maybe I'm reading too much into it, but there are some voice-based cases where voice artists had provided voice prints for a particular purpose, but they got used for something else, and then they're now suing for violation of, in that case, more name, image, and likeness based on their well-known voices. So there can be a set of claims around that. So that was that. Okay, could licensing framework be a viable solution for resolving disputes over training AI? Absolutely. There are different forms of licensing, though, I will tell you. So we do work with a number of big publishers who have granted licenses. One of the advantages for companies to grant licenses is obviously you can generate money by doing it, but you can also license it and put controls and parameters around how a tool can use it, as opposed to them just unfettered scraping of content that may be publicly available and using it for any purpose they want. But yeah, there's definitely a market for it. The other side of this argument is some people say, there should be some compulsory licensing. If you're using content to train AI, you should automatically have to pay a license fee. I don't think it's going to fly. Again, I'm not saying it should or shouldn't. I just think there's a lot of practical issues there. I've been involved in a lot of discussions with the Copyright Office and the ABA, Copyright Committee on this. And I think there's a lot of desire for that. I think it'd be really, really hard to make that work. Are there any tools that be used to determine if work was used to train AI? There are some tools. The one is called Have I Been Trained? I think it's called. I've got a collection of them listed out. If anyone wants the list of the tools, email me and I'll give you a response with some specifics beyond that. But the short answer is yes. You can. There's two types of tools that I'm aware of. At least one is you can tell if some of the tools, again, they're not 100% effective as a disclaimer, but to the extent they work the way they're supposed to, it can determine if your content was used to train AI. The other thing is there's other tools to determine if an output of work was generated by AI. I taught a class, AI law class, and I used that in my class to make sure students were creating original works. Again, they're not 100% effective, but they're out there. Next question. Do you think works generated by an AI which was created by the submitter, if the AI is not named as a creator, do you think it works for a I'm not sure. I think maybe that question is incomplete, but the question is, can you get copyright if you created the tool? I think the answer is going to be no, based on the cases we've seen so far. And, the photograph example is really interesting. I personally think that there may be some revisitation of, the copyrightability photographs. A number of people have raised this issue. You think about the Burroughs case, which is back in the 1800s, which established the protectability of copyright protection for photographs. It was based on the fact that the photographer manually created all the settings, the exposure, any filters they use, the shutter rate, the angle of the picture, the lighting. There's a lot of creative expression that went into it. But fast forward to where we are today, where you could. My brother built a house and he put a camera up on a tripod and left it there for the year or so that it was the house was built, and he created a video that just fast forwarded through it to see the whole thing. Other than putting it on a stand, there was really no creative expression beyond that. Just pointing at a house, right? And so I don't know. I think it's an interesting issue that people have talked about, but there still is, even with autofocus and things like that, there is some level of composition. But I guess the question is, what's the scope of protection, right? You're not getting exclusive rights to what you took a picture of. It's your version of the picture. So people could still take pictures of it, etc. But if you copy that, there's probably at least some minimal copyright protection in those photographs. Okay. And then last question that I see here so far is, if you could manipulate an LM into outputting verbatim copyrighted content, like a book, but no information leaves that chat and gets repurposed commercially at all, do you think the LM has infringed? Well, at least according to some of the cases, it's a question of what you publish. So merely creating a copyrighted work, if you don't use it, I think there's at least an argument that there hasn't been infringement under at least some of the cases, one of the cases that we looked at a minimum. If you do nothing with it. Now, if you do something else with it other than publishing, it could still be an infringement depending on the facts. So I think that's an interesting question, but I'm not aware of any case where that's been found to be infringement.
Awesome. Well, thank you, James, so much for those additional insights. And thank you all so much for your wonderful questions. We want to thank you all so much for joining us for another Justia webinar. As we mentioned earlier, don't forget to take advantage of our powerful free legal resource available for all Justia Connect members, our Justia Daily Opinion Summaries. You can get next day alerts with concise summaries of the latest court opinions in the jurisdictions and practice areas that matter most to you, delivered straight to your inbox. You can stay informed and stay ahead by signing up now at newsletters.justia.com and never miss a key legal development again. Have a wonderful rest of your day. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.